next case before the court is MJ and WH v. Akron City School District et al. Each party will have up to 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. Arguments are being recorded, so please keep your voices up, remain behind the podium, and you should not use the names of children or minors or any kind of victims in your argument. You can refer to those folks by initials or general terms. The judges have read your briefs and they are ready to proceed when you are. And so I would just ask appellant at this time, would you like to reserve any time for rebuttal?
Yes, good morning. I would like to reserve 5 minutes of my time for rebuttal.
Okay, thank you, counsel, and please introduce yourself and you may proceed when you are ready.
May it please the court, my name is Matthew Smartnick. I represent the appellants in this consolidated action, Akron City School Board, and the individual educators at Leggett CLC. It is undisputed that Christopher Hendon perpetrated a massive fraud in the spring of 2017. He conned parents, actual law enforcement officers, staff at the Juvenile Detention Center, and even potentially the mayor himself. Say what you will about Chris Hendon, but there is no dispute from the record that Hendon was extremely convincing in his deception. But only hindsight is 20/20, and a genuine mistake in identity by appellants is not evidence of recklessness to overcome their statutory immunity given to them by the state's legislature. This court should reverse the trial court's decision and hold that appellants are immune from liability under 2744. But the political subdivision, I want to address this before we get into the individuals, the political subdivision itself, the school board, has a different analysis under 2744.02. 4112.02 capital G, the statute that the trial court held expressly conveys liability to the political subdivision. It just doesn't do that. A plain reading of the statute only has a proprietor's employees, keepers, or managers. Those are the only entities that can violate the statute that was in the complaint. Now, 4112.01A1, the definition for the entire section, does have a political subdivision as defined as persons. However, if you actually look at the statute itself that's in question here, G, persons do not violate the statute, cannot violate that statute as defined under the revised code.
G of what section of 4112?
It's 4112.01A1. That's the definition.
That's the definition for person. You're referring to G. What is that, 41?
I'm sorry, 4112.02 capital G.
Okay.
So in the Horn Court, the 6th District, obviously it's not controlling here, but it's the only court in the state that actually dealt with this specific issue, and they said it doesn't expressly impose liability. And notwithstanding that, there is no evidence. I don't think I need to go into too much, but there's no evidence of discrimination on race or disability at all. There's nothing that appellees showed in their brief or in the record that would indicate that any of these educators, lifelong educators in the city of Akron, were discriminating.
Was that issue before the court, or was the court just viewing on summary judgment whether sovereign immunity applies?
Well, yeah, I think it is. I think the main issue here is whether the statute expressly conveys liability against political subdivision, but I think the court can address that with the evidence here, because in order to have an exception...
I guess I'm asking, did you argue, A, the statute doesn't apply, and even if it did, there's no evidence of discrimination, summary judgment should be granted because the statute wasn't violated?
Yes, it came up more in depth in the reply brief. The trial court dealt with that issue and determined that it was not a new argument. So it was brought up below. So that being said, the political subdivision, there's no exception to immunity that applies to the political subdivision. And for the political subdivision, the school board, they are immune from liability under 2744.02. Now, to get to the employees, the trial court really focused in on the recklessness. It didn't determine that there was any willful or wanton misconduct by the individual employees here at Leggett. And they also focused in on the signing in and out. I want to address that real quick. I believe that's a red herring. All indication, it's undisputed that all these individuals, and in this case with the signing in, that would be the secretaries, genuinely believe this guy, Hendon, was a law enforcement officer. So having him sign in saying, I'm Chris Hendon, isn't going to change anything. He still would have been allowed to be in the building because they thought he was a police officer. But recklessness is a higher standard, of course.
Were police officers supposed to sign in under the agreement with the Akron Police Department, or just have police officers ever signed in?
Now, the testimony from the record from the secretaries, no. That was the standard procedure. They knew they were law enforcement officers, and they never had to sign.
Did that comply with board policy as who should sign in?
That's vague, I think, because obviously the board policy says that all visitors must sign in. However, the secretaries at issue, and again, the secretaries are the only ones I think this would apply to. The teachers aren't out there at the front door making sure people are signing in. The principal isn't.
Was there testimony about why that policy existed? Like why you would have someone sign in?
I think because to be honest with you, I don't know off the top of my head what the reasoning behind the policy is. I know it did exist from the record, but I think law enforcement officers was going in and out of the school was very commonplace.
And there is an agreement between the Akron Public Schools and law enforcement, right, the APD, is that correct?
There is an agreement, but there was that was for resource officers. So there also, and I think it's in Rambler's, I believe it's in Rambler's testimony, where cops were coming in unannounced one to two times a week around that time. And actually, not only were they coming in, but they were walking around, they were interacting with students, they were talking to teachers. Not so much different. I know we can probably get into handcuffing in a bit, but not so much different than what was going on at that time. So when Hendon comes in, Delisi, Dorita, Principal Vincente are all seeing him interact with actual law enforcement officers outside. Because at this time, there was a father trying to abduct his kids, essentially. And before that, he's actually introduced by a mother that my boyfriend, a police officer, is coming to pick up my child. So they get from a third party that this man is a police officer. They see him coming, interacting with actual real law enforcement officers. And then when he comes...
Do you think that's a reasonable way for school to determine someone's a police officer because they bomb that the school system says he's a police officer?
I think by itself, no. I think you have to look at, and I think with this recklessness standard, you have to look at the totality of the circumstances. And this isn't just some guy who went and put on a uniform and walked in and started handcuffing kids. He is introduced as a police officer. They see him interact with other real police officers, so they're getting confirmation. Then he comes in and he's showing them, here's a picture of me at a different school, giving an assembly. Here's a picture of me at the juvenile detention center. Here's a picture of me with the mayor. So how do you get from all those circumstances that not only it's evidence of negligence, but negligence of a conscious disregard of a known or obvious risk? There has to be a level of consciousness by these individuals.
Counsel, I was very confused when I was reading the briefs in regard to the school resource officer that was there, because evidently he testified, or I suppose, that he knew he was not a police officer.
Yeah, he did say that, but that's never communicated to any of the appellants. That's not correct. So while he said under oath in his deposition years later that he believed he was a police officer, there's no evidence that he communicated that to any of the appellants. So all they're seeing is him shaking hands and interacting with the Mr. Good, and they're relying on that. And that's kind of, I point to the O'Toole case where there's a reliance, where I think it was an investigator who was investigating child abuse. There was actual physical signs of abuse by the child, and with the investigation determined that wasn't enough. Well, the child unfortunately ended up passing away later, and the court determined that that's not enough recklessness. A genuine reliance on information that they're getting, and even if there's a mistake made, that's not enough to meet that higher standard of recklessness. So the ruse that Hendon pulled on everyone, including parents, teachers, staff, actual law enforcement, caused all appellants to genuinely believe that he was a law enforcement officer. And there is evidence in the record, I want to address this point, of handcuffing. In WH's case, the mom gave permission. She was there, she was present, she was videotaping it. In MJ was not handcuffed. And this whole issue of a police officer, go ahead.
I was just gonna say, counsel, what are we gonna find in the record regarding who knew about the handcuffing?
I believe the only appellant that did not witness any handcuffing was remote. So we know obviously Miss Morrison, the teacher, WH's teacher, she was present when the mom was there and Hendon was there, and they kind of did the perp walk. And then Vincente and the secretaries were aware and did see children in handcuffs. But all those instances, it was with permission of the parents, and they believed he was a police officer. Police officers are, I think, one of the only, I can't think of anyone else in our society that are allowed to handcuff people. So,
Well, counsel, this was elementary school,
correct.
okay, and it seems like every witness testified that they'd never seen any other police officer come in the building handcuff anybody, and they thought it was very unusual.
They thought it was unusual, but what does that, I guess we have to look at the evidence, and what's that evidence of? Is that evidence of negligence, or is that evidence of a conscious disregard of a known or obvious risk?
And that sounds like a jury question.
I don't think it is, because a jury does not determine the law. Immunity there has to be evidence for a jury to determine. And if you look at the totality of the circumstances here, you have confirmation at every indication that he is a law enforcement officer. Even the handcuffing, cops handcuff individuals. I understand you have minor children here, but is that deviation? Is that maybe, well, they should have done this. They maybe should have double checked.
I just want to let you know, you're at 3 minutes and 33 seconds, I'm sorry.
Thank you. So there's no evidence of recklessness. In violation of the statute at issue, there's the reporting of child abuse. Again here, we have no evidence in MJ's case that anyone witnessed any abuse to MJ. WH, here we have, again, the mother was there, she gave permission. They were watching this happen. This was between WH's mother, MH, and Mr. Hendon. The bizarre and unprecedented nature of this case confirms that the individual employees are immune from liability. Mr. Hendon repeatedly and intentionally deceived not only appellants, but the community at large. The deception that was imposed upon them over the course of several days in April 2017 does not meet the high standard of recklessness to overcome their immunity that this state's legislature gave them. Getting conned is not evidence of recklessness. So on behalf of the appellants, we ask this court to reverse the trial court's decision and to find that appellants are immune from liability. And if there's any other questions, I have nothing further.
Okay, you will have 2 minutes and a little over 2 minutes for your rebuttal.
Thank you.
Counsel for the appellate. I'm going to give you 16 minutes, and I'm going to give the appellant another extra minute because I was slow on letting him know when his rebuttal time was being cut into. So I want to just be fair and let you know that on the front side of this.
Thank you, Your Honor.
Thank you.
Ed Gilbert on behalf of the appellee. Clearly, it's our view, Your Honors, that this court should sustain the ruling below. This situation is as bad as it gets. I'm here standing up for, quite frankly, black babies handcuffed, and abused. The testimony below from the superintendent at that time, as well as the principal, is that handcuffing is corporal punishment, period. It's undisputed. And I would like to take a moment to go back and kind of update the court on the facts and kind of explain a few things on the facts. This situation would be continuing today if it weren't for juvenile judge Linda Teodosio, who saw Hendon and James. They don't want to talk about James, okay? But Hendon and James bringing black babies in there.
Just make sure that this is all within the record.
It is in the record. And because of space, we're not able to get all of this into our brief, but it is in the record. Judge Teodosio saw this, immediately called the sheriff, and they arrested Mr. Hendon. There was absolutely no question that what was going on there, just from eyesight, was inappropriate. That's number one. Number two, just to bring you up on the facts as well, we have an expert, Michael Mayer, who is an expert in school procedure. He presented a report on May the 9th, 2022 that answers a lot of your questions as to why is it important that they sign in? Why is it important that they review the signature and what these people, signing in is just not your name. It is name and other information that they could go, they could look at, they could confirm. Mr. Mahan made it very clear in his expert report that this is beyond the scope. He even said that these people, these teachers and the principal need to be, number one, fired, and number two, they need their license taken away. He thought it was that bad. The other item I think we need to bring up, there is mixed statements in regards to Hendon. Hendon, there's a bench warrant out now for him because when this case was
Let's develop ourselves to the record here. I don't think that bench warrant is part of the record of this case, is it?
I'm not, well, the order is in the record, okay?
The order is in the record here.
No, the judge issued an order for a bench warrant for him because
As part of this case.
As part of the state case, correct.
This civil case right here, the warrant is part of that record?
She issued the warrant, and I asked that that warrant be exercised.
Okay.
Okay, so I think you'll find it in the docket, and you also find it in an order. We asked Mr. Hendon to appear for testimony. Mr. Hendon appeared, refused to give testimony, and the court ordered him back in, and they issued, the judge issued a bench warrant, which is outstanding now. Now, I want to take a moment and bring you up to date in regards to James. Mr. Hendon refused to identify James, and the police department to this date don't know who he is. And the principal, Ms. Vincetti, identified him as Hendon's sidekick. And she says he comes in with the sidekick. And not only did they give records to James, but they also allowed James to tag along with Hendon in this whole process where they say, oh, he fooled us and committed fraud on all of us. Nobody, no officer comes in there with a sidekick. That's number one. The second thing is we do have Dr. Franklin's report that also identifies the damage that this was done. These kids were permanently and are permanently damaged as a result of what has occurred here. This is not a joke. This is not something that just can be glossed over. They're saying, so what is their defense? I'll come back to that so what defense.
Well, their defense is whether it's right or wrong, sovereign immunity says the state can't be sued.
Sovereign immunity
So addressing that
clearly is an exception here.
The plaintiff indicates that revised code 41-1202G only does not involve state actors.
Well, we've identified that in our brief. You know, we're relying on the Campbell case, the 2001, the Ohio Supreme Court case. He's relying on the Warren case, which is a Court of Appeals case, which is not binding here. But the most important thing about that keep in mind, that was an OCRC case. And also, they did not review the statute that we actually under here. Okay, so we feel there are some, it's distinguished, and we've outlined that on page 19 of our brief. In addition to that, we are saying that clearly, through our expert report and through the testimony alone and identification alone, all these things that were going on with Hendon shows that there's clearly, any reasonable person would question and raise questions as to who is this guy. First of all, they say that he's in a uniform that they never saw before.
Counsel,
Thirdly,
is there evidence in the record you could point us to, that would, that points to an actual knowledge on the part of any of these defendants that he was not an Akron police officer?
Vincenti herself, in her testimony, questions that. When she gets a call from this other person whoever that person is, supposed to be the girlfriend or whatever, she says she doesn't believe that because the girlfriend is unreliable. She questions that. And then when she sees Hendon grab a kid, puts him in handcuffs, she says, that's strange, I never saw that before. And the whole situation with them thinking that he was, quote unquote, a resource officer, the facts in this don't support that because a resource officer is not supposed to enforce school rules. They're there for some other purpose. And this is a person that didn't follow any rules, and they should have known that. For example, he brings up Mr. Rambler. Rambler says when they have resource officers come into school, he picks up the phone, he calls the principal first. And this is the person that's going to be coming in. And that's in the record. And none of this occurred. Mr. Hendon was there as an enforcer of against disabled black kids, period. And I stand by that. And that's what's going on here. And they admit, each one of these teachers admit that Mr. Hendon really helped us when he came in because some of these kids were bad. And these kids all have IEPs. And they admit that, hey, you know, it was great having him here. And they were not eager to find out what was behind him and why he was doing this. They let Hendon and James come in and have total control of that particular school. And I would like to also point out Angie Sheskry, and her name is spelled Scheiskey. We were finally able to get her testimony. She's a white mother who comes to that school almost every day. And she talked in depth of how she saw these black children lined up against the wall, handcuffed with each other. And she says, my kids are white. And we would have never put up with that. They didn't even try to deal with our white kids that way. And that's what she says. And she talks in depth about how there were some differences between the way these white kids are treated and the way the black kids are treated. And so we feel that clearly that the court below identified and hit it on the head that, wait a minute, this is something that the jury should hear. These are issues that the jury should really deal with as to whether the facts are the way we claim they are. And I believe that if given an opportunity, a jury would in fact find that there was clearly a wanton, reckless operation going on there, and would still be going on but for Judge Teodosio. We feel that the whole issue with the duty that these teachers had, the duty that the principal had, is clear in our minds. And clearly, in our view, immunity should not be applied to anyone in this case. And in regards to the district, 4112 and 4112.01, 4112.99, it's our view that the court hit it on the head as well by saying that, yes, the district is a party, a person in that particular situation, and should be held liable for this. And the court also dealt with punitive damages. And that hasn't been brought up here, but, I mean, this situation is so egregious, so unusual, so, really, it's one of those things where these kids have been humiliated for life. And he says, so what? Their defense is, so what? That's in our view, is a code for, so what? They're black kids, they're just,
Well,
you know,
counsel,
they're disabled kids.
counsel, I haven't heard that, so
Well,
what?
I'm telling you, that's what, I mean, by
okay,
raising the
that's
so
in the
what
record.
defense, so what defense says, who cares? That's what that says. And I'm here to tell you that that's not right. Now, I'm here to stand up for these kids and say, look, we deserve our day in court. We deserve the people to look at this, evaluate it, and determine liability here. We want to be given an opportunity for that. Thank you.
Thank you. And counsel, as I mentioned before Attorney Gilbert began, I want to extend that opportunity for an extra minute to you as well.
Thank you. Thank you. So, you know, just to address the discrimination briefly again, I mean, these educators are lifelong educators. You know, they're not doing it for money. They're not doing it for fame. There's absolutely no evidence in the record that there was any discrimination based on race or disability in this case. And that's the record.
Well, counsel, again, could that be an issue of fact in regard to the fact that there were no white students that were disciplined in that manner? No, there's no testimony that any white students were handcuffed. There was no testimony that any kids without an IEP were handcuffed.
There still has to be evidence to put before a jury on discrimination. There's because the sole fact that in the school, which is 60% African American, that the appellees, the minor children were African American, isn't evidence in itself to present in front of a jury on discrimination based on race. There has to be evidence, and there is none. And this handcuffing with corporal punishment, yes, the teachers were not involved in the handcuffing. They weren't directing there's no evidence in the record that they were directing Hendon to handcuff the students. This was made by a decision made by Hendon in conjunction with the parents.
Counsel, I heard a little bit in the appellee's argument, this idea of a question of recklessness related to not investigating, not knowing. There was a lot going on over time. Would you just address that for me?
Yeah, and thank you for the question. I think it goes to show that this is an evidence of recklessness. It had to go through this entire investigation. It took a judge. It took a judge to say something, then to call the cops. And I think in the record, they actually conducted an investigation. They did a raid on his house. Only after all that, they determined, okay, this guy is a fraud. He's committed crimes. So to kind of put, quite frankly, to put the bag on the educators, on the teachers here, when he was conning a lot of other people besides my appellants here, is not evidence of recklessness. At most, we're talking about should have, and I think I've counted a few times in appellee's argument here where what they should have done. Well, what a reasonable person should do, that's the definition of negligence. It's a deviation of the standard of care. I think we can look back at hindsight now, all this time later, and say, well, maybe they should have double checked, knowing what we know now. But at the time, when we look at all the circumstances, anything that they should have done to double check, that's not evidence of a conscious disregard of a known or obvious risk.
Well, counsel, I'm not sure who it was, didn't the superintendent testify that they definitely violated school policy, Akron Public Schools policy?
I believe so now, knowing and looking back at it, but at the time, the knowledge of DeLisi and DeRita here, they thought they weren't.
I understand, but what I'm saying is, the superintendent of the Akron Public Schools said they violated school policy in regard to signing in.
I believe so.
Okay,
But
and this Mr. Hendon, he came in with a gun, right?
there's testimony, but that's what, again, cops have generally carry firearms.
Did they have any indication, did they testify that they knew which department he was with?
They did not. They thought he was SWAT, although Morrison actually asked, she had a friend that worked night shifts with the Akron Police Department, and she actually said, hey, you know my friend? And he goes, oh yeah, I work nights with them. So there is testimony in the record that he was law enforcement. They thought he was SWAT. He identified that he works nights and that he was coming in during the day. And just to address the policy violation, we know from, butcher this, Arbogite, that a policy violation by itself is not evidence of recklessness. So just because there was a policy violation, potentially, or evidence of a policy violation, that's not enough.
But you can use that as a factor.
There still has to be recklessness, just by the sole
I mean,
purpose.
to determine whether it's recklessness. That's one factor that courts can look at to determine recklessness.
Correct, but I believe the holding is just by pointing, if the only evidence is they violated a policy statute, which the trial court heavily relied upon in their decision, they really pointed that out, that by itself is not enough. And to address the expert here,
Yeah, your time is really
yeah,
up.
Yeah.
So we need to wrap up.
okay, well, yeah, we know from expert testimony can establish recklessness, that's in the brief, the law, that's what the law states.
Okay, Councilman.
And that's all I have, thank you.
Thank you. Thank you both for your presentations. The court will take them under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Again, thank you both for your informative presentation.
Thank you.
Thank you.